The court was instead told this morning, as it was on Monday, that it is just obvious that Guatemala should be permitted to intervene because the three states claim the same territory. Guatemala told you that this was a textbook example of a case for which Article 62 of the statute was designed. That might be so if the Guatemala-Belize case did not exist. But in light of the unique features we identified, it is not enough to meet Guatemala's burden in the very particular circumstances of this case. Those features are not in the textbooks. Notwithstanding the reference to textbooks this morning, the court will have noticed that Guatemala had no response to offer on the submissions of Belize and Honduras on the Gulf of Fonseca case and the Eritrea-Yemen arbitral award. I will add only 2 points on those arising from the submissions of Honduras. The first is that Honduras is quite correct to say that insofar as the Gulf of Fonseca case concerns a right to be heard, Guatemala is being heard in its case with Belize. The second is that if one were to change the facts of this case to make it more like Eritrea-Yemen, the question would be this. If Belize and Honduras, instead of turning to the court, had signed a treaty by which they agreed that Belize was sovereign over the Sapodilla Cayes, would that have any legal consequence for Guatemala? If one then steps from that analogy back to this case, the conceptual position is the same. The court will recognise that this is not my analogy, but the court's own explanation in Burkina Faso, Mali.